Okay, welcome back. We are honored and really delighted to be joined now by SEC Chair Gary Gensler, who was sworn into office on April 17th of this year. He has had a fascinating career, which has included also being chair of the CFTC, a professor at the MIT Sloan School of Management, chair of the Maryland Financial Consumer Protection Commission, and a partner at Goldman Sachs. And we're just really grateful that Chair Gensler is with us today to share his thoughts on the SEC's enforcement agenda. He has asked me to let you know if you have questions, please send the questions in through the questions function, and we'll try to take a couple of questions at the end as well. So, Chair Gensler, let me turn it over to you, and thank you.
Bruce, thank you as well for asking me to speak here today. As is customary, I'd like to note that my views are my own, and I'm not speaking on behalf of the Commission or the SEC. So now let me take you back. 1934, in his first speech as the SEC's first chair, Joseph Kennedy told the National Press Club, and I quote, "The Commission will make war without quarter on any who sell securities by fraud or misrepresentation." Though much has changed since then, technology, financial products, business models are always evolving. I think Kennedy's words still ring true today. Enforcement is one of the fundamental pillars in achieving the SEC's mission. Of course, one pillar is the policy framework itself, the laws set by Congress and the rules enacted by the Commission. But you've also got to examine against those laws and rules, and yes, enforce those rules. That oversight and enforcement are the other two critical pillars. Think about a football game just for a minute without referees. Teams without fear of penalties start to break the rules. The game isn't fair, and maybe for a few minutes, it might look fun, but after a while, it's not fun to watch either. So without examination against and enforcement of our rules and laws, we can't instill the trust necessary for our markets to thrive. Stamping out fraud, manipulation, and abuse lowers risks to the system. It protects investors on one hand, but it also reduces the cost of capital on the other side. The whole economy benefits from that. At the SEC, we follow the facts and the law wherever they may lead on behalf of investors and working family. That means holding individuals and companies accountable without fear or favor across the entire $100+ trillion capital markets that we oversee. It is critical that our enforcement program have tremendous breadth, be nimble, and penalize bad actors so we discourage misconduct before it happens. That means bringing cases that matter to our three-part mission: the investor protection, capital formation, and the fair and orderly and efficient markets in between. And whether it's deceptive conduct in the private fund space, offering frauds, accounting frauds, insider trading, market manipulation, Foreign Corrupt Practices Act cases, reporting violations, or fiduciary violations. Today, I'd like to discuss some principles I've asked our enforcement division to consider as they investigate misconduct and make recommendations to the Commission. First, economic realities. Arbitrage has been a long-time feature of finance. Maybe someone buys something in Paris and sees that they can sell it for a profit in London. That's been around for centuries. But all too often, some folks try to arbitrage the rules and laws between jurisdictions, within borders, across legal entities. I know the lawyers listening know you've done this from time to time, maybe advising a client, or amongst technologies. That arbitrage is something that's inherent in finance, but better focused on arbitraging between markets rather than between laws, jurisdictions, legal entities, or technologies. Activities should be subject to consistent regulation, though, regardless of the entity, the technology, or the business model. If a driver is pulled over for speeding, it doesn't really matter if she's driving an electric vehicle or a gas-powered one. There's an old saying, I've quoted it before: when I see a bird that walks like a duck and swims like a duck and quacks like a duck, I call that bird a duck. Sometimes people, though, are focusing on labels. For example, we hear terms like decentralized finance, DeFi, or currency, or peer-to-peer lending. It can seem easy to take these words at face value, but make no mistake, regardless of the label or purported mission, we will be looking at the economic realities of a given product or arrangement, determine whether it complies with the securities laws. History tells us that when a group of people try to mask the underlying economic realities of a certain product or instrument, investors can get hurt. Further, their pain, those investors' pain, can spread from the financial system to the real economy. So, if you're asking a lawyer, accountant, or advisor if something is over the line, or if you are a lawyer, accountant, or advisor, and you're being asked if something's over the line, maybe it's time to step back from that line. Remember that going right up to the edge of a rule or searching, squinting into something for some ambiguity in the text or a footnote may not be consistent with the law or its purpose. Again, think about the spirit of the law. It's about protecting investors. Second, accountability. Accountability, whether individual or institutional, is an important part of the SEC's enforcement agenda. We'll use all of our tools in our toolkit to investigate wrongdoing and hold bad actors accountable, including administrative bars, penalties, injunctions, or undertakings where appropriate. We'll be prepared to litigate or seek a robust finding of facts if we settle. The public benefits and justice benefits from a robust finding of facts where the public can follow why we've done what we've done, why we've held somebody accountable. It instills confidence in our financial markets when bad actors are held accountable. Moving efficiently and bringing bad actors to justice promotes confidence in our systems. Remedies such as penalties and admissions need to be carefully calibrated to have specific and general deterrent effect. We need to leverage prophylactic remedies like bars and injunctions that protect investors from future harm. Now, when it comes to accountability, few acts rival admissions of misconduct by wrongdoers. When appropriate and when the conduct warrants it, we may seek admissions in certain cases where heightened accountability and acceptance of responsibility are in the public interest. Third, high impact cases. Let me share something with you. Unfortunately, I've learned in my first 6 months here at the SEC that there are all too many fraudsters, penny stock scammers, Ponzi scheme architects, and pump and dump cons taking advantage of investors. We have to protect the public from as many of these scams as possible. We will continue to pursue misconduct wherever we find it. That will include the hard cases, the novel cases, and yes, the high impact cases, whether in special purpose acquisition companies, cyber, crypto, private funds, whether in accounting fraud, insider trading, record keeping violations. I know, you're saying, why am I raising record keeping violations? That might come as a surprise. While these may not grab the headlines, the underlying obligations are essential to market integrity. The books and records, yes, particularly given technological developments. A cop on the beat has to balance both the high impact cases and the everyday fraudster. A high impact case pulls many other actors back from, yes, the line that we were talking about earlier. This prompts legal alerts, client letters, bulletins to go out, compliance departments, lawyers and accountants change internal procedures as well. Such high impact cases are important. They change behavior. They send a message to the rest of the market, to participants of various sizes, that certain misconduct will not be permitted. Now, some market participants may call this regulation by enforcement. I just call it enforcement. Fourth, let me talk a little bit about process in a couple of spots. There are a few processes I've emphasized to our divisions of enforcement and examination, which make up nearly half of the remarkable SEC staff. So first, on timeliness. I think we should focus on bringing matters to resolution swiftly. As the old legal saying goes, justice delayed is justice denied. The defense bar often makes a strategic decision, though, to burn clock. Memories fade, following evidentiary trails can get more difficult. I understand the bar's incentives. Those are different than our incentives at the SEC. We have a different mission to fulfill, and ours is a public mission. Thus, I've asked the staff to cut back on meetings with entities that want to discuss arguments in their well submissions. I believe it's important for the people closest to these cases to be making decisions and eliminating unnecessary process. So if you request a meeting, please make it targeted and don't expect multiple repetitive meetings on the same issues. We've got precious resources. We need to move the docket. We need to be willing and bringing the cases expeditiously, and those that aren't, the facts of the law aren't there to close them. With respect to our examinations division, we expect registrants to produce materials and respond to requests promptly. An examination is not an enforcement action. Thus, firms should not use lengthy privilege reviews to delay responding to routine document requests. This would speed up the examination process for everybody. Furthermore, responding to issues raised in an examination and curing any deficiencies, it's a good way to avoid possible enforcement actions. Second thing on process is our work with other law enforcement agencies. Our fellow federal agencies, law enforcement authorities at the state level, international regulators, and self-regulatory organizations. That's an important piece of what we do. For example, last week, Deputy Attorney General Lisa Monaco announced changes to several Department of Justice policies regarding corporate criminal enforcement. Among the changes, DOJ has instructed prosecutors to consider a corporation's entire history of misconduct, making determinations about criminal charges and resolution. The agency also strengthened prior guidance that to qualify for cooperation credit, corporations must provide the department, this is DOJ, with all the relevant facts related to individuals responsible for the misconduct. In addition, DOJ is considering whether resolutions such as non-prosecution and deferred prosecution agreements are appropriate for certain recidivist companies. While our organizations are independent, our enforcement tools, authorities, and missions are distinct. These changes are broadly consistent with my view of how to handle corporate offenders. Third thing on process, sourcing of cases. Those other law enforcement agencies and self-regulatory organizations are a valuable source of cases for us. But of course, our enforcement staff themselves are a great source of cases. They're the ones closest to the market. They might read a news story. They might find something curious. They might open up a case. They're the real cops on the beat. I can't thank them enough for their dedication to the public. There are also internal referrals from across our whole agency to the enforcement division. When it comes to enforcement referrals, I've asked Acting Director Dan Kahl of our examinations division and Director Gubier Graywall of the enforcement division to evaluate existing practices and see how we can make improvements. Moreover, we benefit greatly from tips, complaints, and referrals in our robust whistleblower program. This program, set up after the reforms that are embedded in Dodd-Frank, this year exceeded $1 billion of payouts since the passage of Dodd-Frank Act. But more importantly, it's the cases, the leads, the information that these remarkable set of individuals, the whistleblowers, have brought to the SEC's attention and other law enforcement organizations. Another source of cases is self-reporting. Look, if you mess up, and people do mess up sometimes, please come talk to us. All things being equal, if you work cooperatively to bring wrongdoing to light, you fare better than if you try to mask it. Cooperation, at least the type that gets credit, means more than meeting your legal requirements, such as responding to lawful subpoenas or making witnesses available for lawfully compelled testimony. It means doing more than the bare minimum. like conducting a self-serving independent investigation. What it means is taking steps that enhance our investigation, allow us to move quickly, and if appropriate, help to identify additional misconduct. So before I close, I want to talk to you and address this audience directly on something. Those of you who are lawyers, auditors, accountants, bankers, both commercial and investment banking, and investment advisors, you all play an important role in our capital markets. Market participants rely on your advice daily, your counsel daily, to organize themselves and conduct their affairs. Within our securities laws, you are also entrusted with certain responsibilities and take on certain obligations as well, directly. Thus, you occupy positions of trust. Though you represent your clients, I get that, you also have an important role in upholding the law, which protects investors and their markets. You can often be the first lines of defense. That's particularly true when a client is getting close to crossing that line. Yep, I'm back to that again. I ask you to think about the economic realities, to think about the duck test, and not to just help paper over cracks, not just to help sort of cover up your client in the ambiguous sort of reading of something when it's across the line and the spirit of the law. In my opening remarks, I quoted Joseph Kennedy, the first chair of the SEC, and to which I'm honored to be the 33rd. But 3 months earlier, William O. Douglas, who you might know later became a Supreme Court justice, he was also the third chair of the SEC. But before all of that, he gave a talk to a room full of lawyers down in North Carolina, just like this room. Well, maybe that was in person, of course. But though times were very different, we were in the Great Depression, the depths of the Great Depression. The 1934 Act establishing the SEC had not actually been signed by President Roosevelt. But there, William O. Douglas was giving a speech to a room full of lawyers. And Douglas told the audience, quote, "Service to the client has been the slogan of our profession." He was talking about lawyers. And it has been observed so religiously that service to the public interest had been sadly neglected. Douglas was suggesting something more. And as with Kennedy, I find myself thinking that what Douglas said still rings so true. You all have your own clients, to be sure. Working in a field such as finance that touches so many lives, though, you also have another responsibility, a responsibility to the public. The public is the SEC's client. They're the ones I think of every morning when I go to work. I hope you do too. Thank you. And if there's any questions, we have the time, I'm glad to take them.
So question one about cryptocurrency.
I figured.
Yeah. So cryptocurrency regulation and cryptocurrency itself are really in its infancy right now. And the question is, where do you hope to see it by the time you are finished with your term as chairman?
Look, I think that the innovations in this space, from Satoshi Nakamoto's paper 13 years ago to the various innovations subsequently, are pressing up against finance and are a bit of a catalyst for change. But it's 13 years. It's a teenager. Yeah. And for it to actually reach adulthood, I mean, to actually make it through those turbulent years, so to speak, I think it needs to come within the public policy framework. Our laws are clear, and I'll quote another great jurist is Thurgood Marshall, who wrote in the Reeves case, I think it was, that Congress painted with a broad brush when they wrote the securities laws, a broad brush to protect investors against fraud and the like. Investment contract was written in, note was written in. There's 35 things that are written in. I think the law is pretty clear here. And so where do I want to see it? Inside of the investor protection remit, that issuers raising money through investment contracts are in, and that the platforms are in. And look, statistically speaking, it's just quite unlikely that if you have 50 or 500 tokens on a platform, you don't have security. So I speak again to you, the lawyers listening, and I ask you, go to the website, read William O. Douglas's speech from 1934, because some of what he said, and it was more fiery than the quote that I just picked up about the legal profession of the 1920s and early 30s, I think is a good hearkening to today. If you're a lawyer representing somebody in crypto and you think about it, you say, is somebody raising money from the public? Think about that Supreme Court test, the Howey test. Then get them to come in, get them to register. Don't just advise them, well, if you set up in this overseas country and set up a foundation here, you can maybe arbitrage the rules for a few months, and with 6,000, 7,000 tokens out there, the SEC might not get around to you first. They might get around to you later. So what would I like? I would like this field to be inside the investor protection perimeter, which I think the laws and the rules are clear on. I'd also like to ask this profession, people listening, to remember you have a greater responsibility than helping some folks sort of take money out of the public's pocket and try to avoid being underneath these broad laws that Thurgood Marshall wrote about.
Let's try one more question. What guidance would the SEC give to companies making ESG disclosures while awaiting agency guidance?
Well, what we have now, it's a really good question. What we have now is a significant amount of interest from investors for climate risk disclosures, particularly, and then some of the other disclosures you just mentioned. And I have asked staff to work on, from a policy perspective, to work on putting a recommendation in front of commissioners that we'll put out to the public for public comment. In the meantime, and before we finalize that, hundreds, if not thousands, of companies are making disclosures. So it goes back to the basic bargain again of those remarkable individuals in the 30s, that investors get to decide, but companies have to give full and fair disclosure, and you can't mislead the public. You shouldn't say that you're doing something that you're not, and particularly, as you all know, if it's material. So it's really being thoughtful and prudent about those disclosures that are now voluntary, that we're going to consider through notice and comment having mandatory disclosures about. But if a company says something about their greenhouse gas emissions, about their aspirations, about how climate risk is affecting either their physical transition or the physical risk or transition risk, to make sure to, one, follow some guidance written in 2010 by the SEC, but more broadly, to make sure that it's doesn't have material omissions and it's correct.
One more question, referring to Lisa Monaco of the DOJ's recent speech about, the question is, should the audience infer from that the SEC Enforcement Division will be trying to put a greater emphasis on individual accountability, charging individuals alongside companies?
I think that it's a really important piece. It's part of why, when I just organized for this conference and speaking, I highlighted accountability, economic realities, accountability, and yes, some high-profile, high-impact cases, along with the incredible, unfortunately, too many fraudsters and so forth, but accountability of individuals and the companies. Sometimes that means the robust recitation of the facts and as to, well, where this was done in an organization and how it came out and so forth. Sometimes that includes bars for service in the financial industry. And yes, sometimes it means admissions, and sometimes it means partnering up with the criminal authorities, either at Main Justice or across this land with the various U.S. attorneys' offices and the like. But I think that's an important piece of this.
Well, Chair Gensler, it's been really great to get your thoughts, and I really appreciate your remarks today. On behalf of everybody in the audience and around the world who's listening, thank you so much, and I hope we can speak to you again.
Bruce, it's so good to be with you. And I gave you a little call to action at the end there. And so I hope that you can take the public interest at heart while you're thinking about your clients as well.
Thank you.